Good morning, everyone. It is 10 a.m. on Thursday, November 9th, and I am calling to order this meeting of the Public Safety and Justice Committee. Colin, would you begin with a roll call vote, please?
Vice Chairperson Chavez. Here. And Chairperson Ellenberg.
I am here as well.
Quorum.
Thank you very much. We will go directly to public comment. This is the portion of the agenda set aside for members of the public wishing to address this committee on matters not on our agenda today, but within the purview of the Public Safety and Justice Committee. Do we have speakers?
There are no requests in the room, and there are no requests online.
All right. With that, we will look at the consent calendar. I would request, please, that we hold Item 12, which is the proposed 2024 meeting schedule, until November. There's still 2 dates that we are working to nail down. Other than that, do you have changes? None. Would you like to? Second, do we have public speakers on the consent calendar?
There are no requests to speak in the room, and there are no requests to speak online.
All right, let us vote on the consent calendar.
Vice Chairperson Chavez.
Yes.
And Chairperson Ellenberg.
Yes.
Motion carries.
Thank you very much. Now to some actual exciting substance and content. Item 4 is the in-custody mental health assessment and treatment report. And I know there has been a tremendous amount of work put into this report by a good number of partners. So looking forward to the presentation and the conversation.
So I'll be introducing the item this morning. Good morning, everybody. I'd like to introduce a couple of my colleagues from the Office of the County Council who will be leading the presentation today. Melissa Kiniakoulis and Megan Wheelahan are at the staff table. They will also be joined by their colleagues, Allison Gomez from the Public Defender's Office, Brandon Cabrera from the District Attorney's Office, and Gabby Olivares from Behavioral Health. So just to set the stage a bit for this discussion, we have a pretty thorough presentation with a number of subject matter experts today. And one of the key goals of the presentation is to try and just clarify, because these are highly technical processes that involve, overlapping statutes. I like to think of it as sort of a Venn diagram with partly overlapping parts and some that don't overlap. But one of the key goals is to try and clarify the distinctions between the processes and the populations that are subject to the incompetent to stand trial process, which is a legal process, and then the clinical treatment processes that are administered by behavioral health. So with that, I'm going to turn it over to, I believe, Melissa to get us started with the first couple slides.
Thank you. Good morning. Can everyone hear me okay? Great.
Yes.
Thank you for this opportunity to present to the Committee on Mental Health Assessments and Treatment for Criminal Justice Involved Persons. I'm going to begin with a description of the types of mental health services provided in custody health services to patients in the county's jails. And my colleague, Ms. Wheelahan, will discuss mental health services throughout the criminal process. Custody Health Services provides medical and mental health services for all patients in custody in the county's jails. And the focus of this presentation is on the mental health treatment provided by Custody Health Services, which starts at the time of booking. Custody health nurses conduct a health assessment for all patients during the booking process. Based on the custody health nurses' assessment and screening questions, they decide whether to refer patients for mental health assessments. And for these referred patients, mental health clinicians perform assessments during the booking process to assess patient needs for mental health services during their incarceration. But this certainly does not mean that patients who are not flagged at the time of booking would not receive mental health services thereafter. Anyone can refer patients at any time during their incarceration for mental health services. Referrals can be made by custody staff, medical staff, mental health staff. Patients themselves can request mental health services, or anyone else in the jail can make a referral for services. Next slide, please. There are various types of mental health providers within custody health services, including psychiatrists who provide acute and outpatient services, psychiatric nurse practitioners who provide psychiatry outpatient services, psychologists who provide counseling and testing services, mental health clinicians, and these include licensed clinical social workers, marriage and family therapists who provide assessments, counseling, and crisis responses, and psychiatric nurses who provide services in the acute psychiatric unit. Next. Custody Health Services provides a robust level of mental health services for patients throughout their time in custody. Now, I've already briefly discussed services provided at the time of booking. At the most intensive level of treatment, Custody Health Services provides inpatient psychiatric services in the acute psychiatric unit for patients with the highest mental health treatment needs. There are also special management units, which are housing units designated for patients with serious mental illness who do not meet criteria for the APU, but who need mental health services in a setting where they can receive regular clinical assessments and structured programming from Custody Health mental health providers. Custody Health Services also provides outpatient services for patients who are not housed in the APU or an SMU. And Custody Health Services screens patients for suicide risk at the time of booking and can place patients at risk of suicide on precautions if necessary. And it's not to say that this risk assessment only occurs at booking. Again, if a patient's circumstances change and they require some type of suicide risk assessment or suicide precautions, that can occur at any time during their incarceration. Mental health providers and Custody Health Services engage in multidisciplinary treatment planning, behavior management, and discharge planning. Now, we're going to discuss the process for assisting patients who require conservatorships upon release from custody and patients selected for diversion in a few moments. Next slide. Custody Health mental health providers recognize that involuntary administration of medication is a drastic measure. Custody Health Services psychiatrists do not seek involuntary psychiatric medication orders on all patients with serious mental illnesses. Rather, psychiatrists seek involuntary medication orders for patients who are in dire circumstances. These patients may not eat or take their medication. They may not take care of their personal hygiene needs. They may refuse to shower and change their clothes. They may refuse to leave their cells or clean their cells, which could become dirty and cluttered with food containers. Could also result in some patients who are spreading feces or having urine on the floors of their cells. And because of their serious mental illnesses, they're unable to take care of their basic needs. These are situations where custody health psychiatrists have determined that it would be inhumane to allow seriously mentally ill patients to deteriorate in their cells without any intervention. And it is only under these serious situations that the county counsel's office seeks to obtain court orders for involuntary psychiatric medication for patients in custody. Criteria under Penal Code Section 2603 to obtain an involuntary medication order include that a psychiatrist has determined that the patient has a serious mental disorder, and as a result of that mental disorder, the patient is gravely disabled and does not have the capacity to refuse treatment with psychiatric medications, or is a danger to self or others. When a psychiatrist has made these determinations, the county counsel's office files a petition for an involuntary medication order, and the patient is represented by an attorney from the public defender's office. Penal Code Section 2603 requires 21 days' notice before a court hearing. Because of the seriousness of the patient's circumstances at the time the petition is filed with the court, attorneys from the county counsel's office and the public defender's office may agree to advance the hearing date if the court is able to accommodate the request so the petition can be heard sooner. The patient has the right to be present at the hearing and to be heard. And if the court, after having the hearing and hearing from all sides, grants the petition, an involuntary medication order is valid for no more than 180 days. The court reviews the order at 60-day intervals to determine whether grounds still exist for the order. And that review entails a hearing where the patient and their counsel are allowed to be present and be heard. If grounds for the involuntary medication order continue to exist after 180 days, and if a psychiatrist recommends that the involuntary medication order be continued, the county counsel's office can file a petition to renew the order. But it's important to note that if a psychiatrist determines that a patient no longer needs involuntary medication, so for example, if a patient has been receiving medication and their condition improves and they are willing to voluntarily take their medication, the psychiatrist can let my office know and the county counsel's office can ask the court to discontinue the order. Next slide. If custody health provider concludes that a patient who is about to be released from custody meets conservatorship criteria under the Lanterman-Preter-Short Act, the provider can flag the patient for an involuntary psychiatric hold upon release from custody. The county counsel's office would file a petition for a conservatorship with the court before the patient is released in jail. So the timing of these petitions are key because it needs to be shortly before the patient is released if they meet these criteria, but my office still needs time to file a petition with the court and get a conservatorship in place before the release. If the court grants the petition for conservatorship when the patient is released from jail, they would go to EPS, BAP, and then on to available treatment facilities in the community. Next slide, please. Thank you. And custody health services may also refer patients to behavioral health for an assessment and connection to services upon release from custody. So unless there's any questions for me at this time, I'm going to pass the microphone on to my colleague, Ms. Wheelahan.
I want to ask just a quick clarifying question. If a person meets eligibility for conservatorship before they leave jail, why would they have to go through the steps of EPS and BAP? If they're already conserved, why would they not go right to a placement?
Well, it's a lot of facilities do not want to accept a patient directly from jail.
And they think it'll be different if it's... Is that a substantive treatment-related issue, or is that a stigma where we can then say they're coming from EPS and not coming from jail?
Maybe I can speak to that a little bit. Where someone is going to be released from jail and they're conserved and they need some type of locked treatment, if no other treatment is available, BAP is generally where they will go because it is the county facility. We will accept anyone who needs to be in that type of secure environment. So certainly if there has been time, opportunity, and capacity to actually place the person in a specific facility where they can stay long term, they would go there. But Megan, I don't know if you want to add anything on that front, but I will just say BAP is often the facility of last resort where a longer term treatment option is available. And if the conservatorship proceedings conclude right as the person needs to be released from jail because their time to be held in jail has ended, that's often where people will be taken if they don't have another placement and they do need that locked psychiatric environment.
Thanks. BAP actually makes more sense than EPS, but I appreciate it. I don't want to derail the presentation. I just wanted to make sure I understood that piece.
Yeah, just quickly on the BAP EPS. Typically, BAP is always full, right? So people go to EPS to wait for a bed at BAP. And if they're coming out of jail, it would depend on their level of acuity, whether they could go to a subacute facility or an acute facility. And typically, they do need acute stabilization prior to going to those subacute facilities.
Megan, just lean into the mic a little more.
Oh,
It's a little
sorry.
hard to hear. Thank
Did you hear what I said?
I did.
Okay,
But
great.
thank you. The lean-in is helpful.
And I would say, especially for our criminal justice involved population, as you both know, BAP is often full, not because we have that many people who need BAP level of care, but because there isn't the subacute capacity to take patients ready to be moved down to subacute. And that's particularly true for some of our more complex folks in terms of behaviors, needs, and history, including some of the folks who'd be coming out of jail.
Okay, thank you. So we're going to talk about mental health treatment court, ISD diversion court, and what IST restoration is, just to get each of these kind of areas of evaluations and treatment or other programs clear in our heads. So next slide. So the Santa Clara County Superior Court, Behavioral Health Services Department, the district attorney, and the public defender all collaborate on mental health treatment or diversion court, sometimes called collaborative court. So really the same courts, but different pathways to get there. As described to this committee in previous reports and another report up to date, there are 3 tracks through which an individual in the criminal justice system is diverted into treatment. There's mental health treatment court, or track 1, which is a post-sentencing program for clients who have a mental health condition, are willing to accept treatment, and are not found to be incompetent to stand trial. Mental health court for ISTs, incompetent to stand trial folks, are track 2 and 3. These are for clients with a qualifying mental health disorder where the disorder was a factor in their crime and the individual is assessed to be likely to respond to treatment. The individual must also be found by the court to not pose a danger to the community if released to treatment in the community. Track 2 clients are referred after being found IST on felony charges. Track 3 clients are referred after being found or agreed upon as ISD on misdemeanor charges. Persons found IST on misdemeanor charges are automatically diverted quickly to mental health treatment court. There's also a newer initiative, which I'll let Brandon Canberra talk about in a little bit, to divert clients to treatment sooner in the criminal justice process through a pre-plea agreement. Clients diverted to services through that process are typically individuals with a known history of mental health treatment through the county with lower level offenses who are amenable to seeking treatment. Let's go to slide 10. Thank you.
Brandon or Allison, were there comments you were planning to add on this one before I go to slide 10, or shall I advance?
Okay, so Behavioral Health Services Department clinicians assess individuals who are referred to mental health treatment court and mental health diversion court either through track 1, track 2, track 3, or really anyone for whom a referral is submitted by any of the partners in the justice system. The Behavioral Health Service Department's clinicians' assessment is a clinical assessment of the client's behavioral health needs when they are released into the community. The elements of these assessments are here. They're looking for the presence of a mental health or substance use disorder, the individual's willingness to participate and engage in treatment, a type of insurance and responsible care provider. If the individual is Medi-Cal or unsponsored, those are county beneficiaries who Behavioral Health Services Department serves. If the individual has a managed care plan or a private insurance plan, they are also connected to treatment through that type of insurance. They're also looking at the medical necessity for specialty mental health services or substance use treatment, the level of care that will be medically necessary to meet the client's clinical needs, whether that be residential, outpatient services, or intensive, and the person's housing status in order to connect them with resources appropriate to that need. These assessments are based on the review of available medical records, including custody health records and any previous outpatient mental health records, and a face-to-face evaluation of the individual if possible. It's important to note that BHSD clinicians are not assessing whether the individual is incompetent to stand trial. That's a different legal assessment that we're going to talk about. That's made by evaluators who are specifically trained to make those kinds of evaluations. They're also not assessing whether the individual is a danger to the community, which is a forensic assessment that the clinicians don't perform because it's not part of the individual's clinical needs. The BHSD clinicians are also not assessing whether an individual meets LPS conservatorship criteria or LPS criteria for a 5150 hold. Those assessments are either performed by custody health, who's providing care to them on a day in, day out basis, or by inpatient physicians if the individual is released from jail directly to an LPS facility, such as EPS or BAP. Next slide. So every client who is served through the mental health diversion courts, whether that's track 1, track 2, or track 3, is connected to a level of intensive treatment. These are the array of placements and treatment options that are available really to all clients who are leaving the jail who have mental health or substance use needs. About 70% of behavioral health clients who are leaving the jail have co-occurring mental health and substance use disorder needs. Thus, many of these programs offer treatment in both of these categories. And each category on this slide may represent one or more programs run by either county staff or county contracted agencies. The majority of behavioral health services departments' provider network is composed of contracted agencies.
So, Megan, one of the things, and it's not a question to be answered now, but just in terms of really understanding this slide, which I think is critical, it looks like a glorious and beautiful continuum of care. What I would be interested to know is what are the specific facilities in each of those categories? What is the capacity of each of them, and do they have wait lists for people to get in? Because I'm really trying to understand actual access and availability, because this looks really good, but we know that there's often a disconnect with how quickly people can actually access the need. So I will make that request now to get that information off agenda, please.
Sure, and happy to do that. I will say, just to expand a little bit on what Megan said, this same service array, with the exception of a few programs that are forensic population specific, is the same service array that we're talking about in all these other contexts for behavioral health. So, for example, a crisis residential facility, not only utilized by our criminal justice involved population, but the population writ large served by behavioral health. So, we can look to see how we can best, maybe a question of clarification on your interest. We've definitely looked at some of those questions in the context of just the broader service accessibility at different levels of care, and we can try to augment that. But if you want us to be really laser focused on the criminal justice population, that would be a slightly different analysis, in part because some of our general capacity for some of these services are ones where we have a harder time placing folks with significant criminal justice involvement as opposed to people who might otherwise qualify for that level of care.
Which is what I would expect, and part of the reason that we're so focused on getting some of our own facilities redesigned or new facilities built. It's related to the question that I posed at the board meeting on Tuesday at Judge Manley's urging as to what is actually available to people that are involved in the criminal justice system. So
Okay, that's what
for
I
these
thought.
purposes, that's what I'm particularly interested in.
So we can take a look at what's the kind of best way to present that information. A lot of these facilities, as I know you know, don't maintain a wait list. They basically let us know when we reach out whether they have a space or not, but because it's a function that we have to move a person to another facility, if that facility can't take them, they don't structure their inflow and outflow of patients quite that way, but we'll figure out the best way to present what is the best measure of capacity and gaps.
Thanks. And just, I'll jump ahead and then plop right back. When we talk about item 5 and look at all of the behavioral health section at the end of that report, talks about the number of people on the JAC list and the folks that are waiting. One of the reasons is capacity. Of course, there are many other reasons, but if we're seeing an average of 14 days that people are waiting, that tells us essentially that there's a 2-week waiting list to get into most facilities.
Some of it has to do with when facility capacity is available. Some of
Right.
it also has to do with a few other factors, but
Right,
definitely
right. I
we
saw
should,
the list of all of those.
Would definitely like an opportunity to kind of unpack some
Right.
of that when we get to that item, because there's definitely more to share on that front.
I'm sure. Thank you. And
Just
thank
if I,
please,
if I could on
Supervisor
this
Chavez,
same
yes.
topic, I mean, I think one challenge, and I'll say this to you, not to you all, because this is not necessarily something that I expect everybody who's presenting to know, but I just want to emphasize that when we get presentations like this without numbers, it dramatically impacts my understanding of availability. And I want to go back to the point you just raised, which is if in some instances we're holding beds either for victims of domestic violence, or I'm just using that as an example, or somebody who's coming out of custody, that would be helpful to know, because I think the question that's being asked is if these aren't really available because they're part of our entire system and we're not setting aside beds, or in some circumstances we are, that would be helpful to know. Because again, I'll say what I said on Tuesday, which is it's hard to align what we're seeing based on the feedback we're getting from in this instance, our system justice partners, but even in the community as it relates to mental health overall. So I just want to say, if you're getting this back, what would be good to know is if there's a set aside of a larger number, that would help me understand what kind of flexibility there is in the system and what the real access is.
Good, thank you.
And then on this one, CHS, what does that stand for?
Custody.
Custody health
Services.
Okay, thank you.
Live in a world of abbreviations.
I know, thank you.
Let's go to the next slide, please. So important to note that the placements on the previous slide are voluntary placements. Individuals involved in one of the diversion courts must agree to participate in the treatment that Behavioral Health Services Department offers and the placement offered for post-release. Most of the programs do require that patients comply with treatment in order to be accepted. This often means that the client must be compliant with prescribed medications in order to ensure that they have a level of stability to be successful in the programs. The programs offered by the Behavioral Health Services Department don't have the ability to force medications. That can only occur in the jail through the PC 2603 process that Melissa described, or the involuntary medication order process through the criminal court, or in an LPS facility through another legal process. So we'll discuss the IST process in order to sort of situate the evaluations that occur within it and what an IST finding means for the individual in their treatment. The IST process generally begins when the person's attorney declares a doubt as to the individual's ability to understand the nature of the legal process. Oh, you want to do it? Oh, great. Yeah, I'm going to pass it off to the expert on this issue, Allison Gomez from the Public Defender's Office.
There you go. Good morning. So for the IST process, it's a legal determination, not a diagnosis. And it means that a person is unable to rationally assist their attorney or understand the criminal proceedings. So at any point in the proceedings where a person has court hearings, from the arraignment to trial to probation or parole violations, a judge or defense attorney having concerns about a person's ability to rationally understand or assist their attorney, they can declare a doubt pursuant to Penal Code 1368. A person is not incompetent to stand trial simply because the court or attorney has concerns. There must be an evaluation by a psychiatrist or a psychologist appointed by the court before that determination is made. And again, this is not treatment, it's a legal process. A declaration of doubt does not trigger mental health treatment in the jail, although that can be ongoing as described by my predecessors in this presentation. Once a doubt is declared, criminal proceedings are suspended and the case is routed to a courtroom that's dedicated to competency proceedings. And for felony cases, that is in Department 25 on Friday mornings. And there are some delays at this stage because due to the number of cases in competency proceedings, the size of the calendars, limited staffing, cases are set on the first available Friday, not necessarily the soonest Friday after a doubt is declared. So it might be a few weeks after a doubt is declared before the case first appears in competency court. And at that first Friday competency calendar, the court appoints a doctor from a court panel to do the competency assessment. It can't just be any doctor. They have to have special forensic training to be able to do these evaluations. The assessment is not done on that initial Friday. On that first Friday, the doctor is assigned by the court. A new court date is set about 6 to 8 weeks in the future to allow the doctor to be notified, the evaluation to occur, and a report to be written and submitted to the court. The assessment, once a doctor is assigned, can be done in one of 3 ways. There's a clinic on Monday mornings in the courthouse where a doctor can meet with, I think, up to 3 clients on that Monday morning. They can do an in-person visit at the jail, which is scheduled at the doctor's convenience, or it can be done via Zoom, which has to be scheduled by the attorney. If a client needs an interpreter, this must be done via Zoom. There can be delays during this evaluation process if a client is not transported to the clinic, if they refuse to attend the video conference or the jail meeting. And so new arrangements will have to be made and delays will occur in terms of the report getting submitted to the court. The next court date will be a receipt of report date. Delays can occur here if the doctor didn't submit their report on time, if the client refused the evaluation, if records are missing. There's sometimes delays in doctors getting records that they need to do a full evaluation. But once all of those steps are met and a report is written, it will be submitted to the court and both the district attorney and the defense attorney. On the receipt of report date, one of 2 things can happen. There can be a stipulation to the report by the attorneys. If a report says competent, the defense attorney can agree that that is sufficient. If the report says not competent, the DA can agree that that is sufficient. But if either the DA or PD or defense attorney, not necessarily a public defender, do not agree with the report, either side can ask for a second second evaluation and report to be completed. Additionally, if a report comes back finding a client not competent, both the defense attorney and the DA agree that that report is sufficient, but the client objects to the finding of not competent, they can request that a subsequent evaluation be conducted as well, and the court must appoint a subsequent doctor. After a second report comes back, if it comes back split, where one doctor finds competent and one doctor finds not competent, a third doctor can be appointed. So the evaluation process can be very lengthy. Ultimately, once you have all of the reports, either the reports can be submitted to by the attorneys or there can be a court or jury trial if there is not a consensus or an agreement on the status of the client's competency. So after receiving the reports or via trial, if the conclusion is that the client is competent, criminal proceedings will be reinstated in the same posture that the case was in when the doubt was declared. If the conclusion is that the client is incompetent, then the next step is determining whether the client will qualify for our Track 2 diversion program, which is diversion from the state hospital into our mental health treatment court, or if they need to go through restoration proceedings through DSH. When there's a finding that a client is incompetent, the court evaluator will also have made a determination as to whether or not they have the capacity to make a determination about whether or not to take medications. If the court doctor finds that the client lacks capacity, an involuntary medication order can be issued by the court, which is separate from the 2603 involuntary medication order and lasts during the time that the client is incompetent to stand trial. And if the court does find that the client lacks capacity, that involuntary medication order can be imposed or can be utilized by our custody health to have them take medications. And prior to 2019, all of the felony clients that were found incompetent would be sent to the Department of State hospitals. But with the passage of Penal Code Section 1001.36 in 2019, our county developed a process to divert the clients from DSH, and that's what we have labeled Track 2. And I'm going to pass this over to Brandon Cabrera from the DA's office to talk about Track 2 and DSH options.
Brandon, just before you start that, I just wanted to emphasize something that I think, as you can see, this is profoundly complex, but I just wanted to put an exclamation point behind something that Allison was trying to really differentiate, which is this is a very lengthy legal process about whether a person can actually be criminally prosecuted because they can assist their attorney sufficiently in defending against that prosecution. All the while that this is going on, they are still receiving, if they're in custody, mental health evaluation and services from custody health to deal with their underlying condition. They may, even if an involuntary medication order doesn't issue through the competency process to try and get the person to a level of competency that they can help defend against prosecution, they may separately get through the county counsel's office, also their public defender in the court, an involuntary medication order that's really focused on getting them well enough to be okay while they're in custody. But as you can see, there's a lot of overlapping processes, and this criminal legal process associated with incompetence to stand trial really has to be and is appropriately separated from what is a treatment of a patient by custody health or behavioral health if you're talking about somebody who's out of custody.
And that's actually the next slide. Thank you, Greta. But before we move on to that, I think there's an important point on this particular slide. You might be wondering, why does that process take so long? How many people are coming for incompetence to stand trial? We ran the numbers, and each year in Department 25, Judge Paul's department, there's over 884 evaluations done in any given year for people who are found at that moment in time to be potentially incompetent to stand trial. For all those evaluations, we have currently 9 evaluators that are on the panel that the court will select. You're going to go evaluate this person next week. Sometimes, generally because of the numbers, there's often an agreement early on in the process. We'll look at the nature of the charges, if it's not serious or violent. Oftentimes, both sides will agree after one doctor to expedite this process, to either get someone to the Department of State hospitals or to our treatment courts earlier. But I think the numbers are important to see. There's usually about an 8-week turnaround to get a report from a referral to one of the doctors as well.
So Brandon, let me just understand that. It sounds like the process itself, with all of its potential checkpoints, which I understand are certainly critical to protect a patient's civil liberties and health. If we had more evaluators, it would still take about the same amount of time, right? So is the issue that I just want to separate the issues that we have 9 evaluators, oh my gosh, that's not enough. If we had 30, this could happen faster. Or even if we had 100 for each evaluator, each case would take about 8 weeks.
No, more evaluators wouldn't hurt. We can move through the process quicker with more evaluators.
And tell me how that is, since each evaluator would still have to go through their all of the steps with each client.
Each evaluator would have less clients that they'd have to go see. So
fewer
they're
clients.
actually going to a clinic in court, or they're going into the jail, and they have a huge list of clients that they have to get through.
Okay.
So if we had more of them, they'd be able to have less workload. They'd be able to get through it a little bit quicker.
And these are court employees?
Contracted
I
to
judge.
the
Hang
court.
on.
Contracted
They're
folks, yeah.
They're not court employees. They do have contracts with the court.
And does the court have 9 evaluators because it's incredibly hard to find them, or because there's funding for 9 evaluators?
Because they're contractors, they have to accept the court's contract rate. Depends on what type of evaluation. For example, in the juvenile competency arena, special training is required. It's harder to find those people. The court also doesn't pay particularly well. So often what happens is the individual evaluators simply ask the court to go above and exceed our contractual amount, which we often do. But all of that requires a number of qualified applicants, and we simply don't have very many.
So the qualifications are a little bit separate, such that even if somebody could pay more, there's not necessarily a pool, although certainly a higher rate might encourage people to make themselves qualified.
I'd say both of those are issues, right? If we paid more, maybe more people would apply. We did raise our rates last year for the first time in a decade. I might contend that they are still under market, which is why we often have the excessive fee request, which we often grant, but the professional doesn't know that going into the evaluation.
Got it. Thank you. And thank you, Brandon, for the pause
I think
there.
we were going to both say, though, these numbers, even though they sound low, across the state, they're pretty comparable. We're not super low compared to other counties based on our population size.
Okay.
It's just a very hard job to fill, in
Got
all
it.
honesty.
Thank you so much.
If we go to the next slide.
Greta, is your light on to add something?
Well, I was really just going to take a moment to also just highlight what I think is really wonderful. And Brandon, I hope you and Allison will also speak a little bit more to this, because I think it would be helpful for everyone here to understand just how wonderful a solution to the problem of protracted incompetent to stand trial processes, the diversion of a lot of folks to mental health treatment court, where there's agreement that the real underlying cause of the criminal activity at issue was the symptoms associated with the mental health disorder. And in a lot of communities, they are not doing what we're doing here, which is really trying to focus for those lower level offenders and where there's a path to treatment on really suspending what would otherwise be a really lengthy back and forth around incompetence to stand trial, and trying to much more quickly route those folks to the treatment that will actually address the underlying mental health disorder.
No, I agree, Greta. We're going to talk about track 2 and diverting people from DSH, but I think this county does a lot of things right. That's one of them, in diverting people from the state hospital. The other thing is what we do with misdemeanors, track 3. Before, maybe 2 or 3 years ago, what we would do would be, if a doubt was declared whether you were felony or misdemeanor, you'd go through the same exact process. You'd go to Department 25, you have a doctor appointed, go through that entire process. What we quickly learned, though, on misdemeanors is by the time, as you saw, you go through that entire process, we're out of time to provide treatment at that point. So we proactively decided in this county, let's get these people, misdemeanor clients, let's just get them to treatment sooner. Because if they were found incompetent to stand trial, before what would happen is you just go to mental health treatment court anyways. So we're being proactive, and we're sending now every misdemeanor where a doubt is declared immediately to treatment. Let's get you back on your feet. Let's get you treatment. Let's get you medicated. Let's get you back into the community. I think it's very different than any other county does, as well as our track 2, which we're going to talk about in a little bit. This slide right here is really describing the difference between, we kind of already talked about this, but competency restoration versus mental health treatment court. I think the best way to conceptualize this is the departments. So what Allison was talking about, competency restoration, think of it as Department 25. Felony cases in Department 25, Judge Kelly Paul, as opposed to mental health treatment court, which is Department 60s, 60, 61, 62. That's where mental health treatment is done, and that is focusing on addressing a person's mental health symptoms and improving their ability to function back into the community. What we're talking about in competency restoration is getting the person competent to stand trial again. So the prongs there are, can the person understand and participate in this criminal process? Can they rationally assist their attorney in their defense? The other thing that they have to do to be competent is understand the criminal process itself. What is a judge? What is a judge's role? What is my attorney's role? What's the DA's role? What is my plea options? Do I understand what I'm doing? Do I understand this criminal process? Whereas mental health treatment is focusing on none of those things. It's not about competency, it's about getting you treatment, getting you back into the community. As it relates to, let me see if that's on there. Yeah, with regards to competency restoration, medication is at the front line of the treatment, and it's a set curriculum. Again, can we make this individual understand the players involved, and can they rationally assist their attorney in defending their case?
I was just going to add it. Sometimes it's helpful, I think, to think of incompetence to stand trial as an issue that comes up for people with an intellectual disability, not just people with a mental health disorder, because in some ways thinking about this treatment issue versus competency restoration issue is more complicated in the mental health context. But when you think about somebody with a permanent intellectual disability, that's not something for which they can get treatment to recover. What competency restoration looks like is kind of teaching them at whatever is their intellectual capacity, just really basics about what a courtroom is, that this lawyer is your lawyer, the difference between the district attorney and their counsel. And so a lot of what is happening also for folks with a mental health disorder is really that same approach to just a basic understanding of what the criminal process they're about to be a part of is, in addition to then trying to get them mentally well enough. But that intellectual disability example, I think, sometimes helps people better understand how competency restoration is different than treatment.
I would just add to that briefly, as well as what Greta said earlier, that I think what Brandon is describing now and what he and Allison and Megan will continue to describe through the rest of this presentation are the ways in which, as Brandon was explaining, Santa Clara County is more treatment focused than really any other county in the state, and he can provide further details on that. But I think this really helps get at questions that have arisen about why doesn't the county provide competency restoration services in-house, and the reasons that occurs at the state hospital, that we've taken a really different approach in this county because competency restoration isn't treatment. It addresses something entirely different, as Greta just said. So I just wanted to set the stage a little for that and explain this point about why this is the focus at the state hospital and why it's not being provided in-house at the county.
If I could make one tiny more additional comment with restoration, back to Brandon's earlier comment, it can require the need for further additional evaluations, right? It's possible for the court to have someone restored to competency, then a doubt be declared again, then an evaluation occur again. And for mental health treatment court, it's very different treatment focused, but for restoration, we might generate, an endless number of evaluations in that forum.
Thank you. And Sylvia, go ahead.
I think the issue too in that process that we've discussed is the quality of the evaluations. And you may be asking, why do we have to do so many evaluations, or why do we request a reevaluation, or why would somebody declare a doubt, again, once they're claimed to be restored? There's a big issue with the Department of State Hospitals' quality of evaluations, in particular with a nuanced issue of whether or not the Department of State Hospital evaluators can effectively capture the ability to assist portion of the standard of competency. And that has been an issue of contention because oftentimes they're not attorneys, they are obviously experts, but that is an issue that can be overlooked. So an attorney, once they say this client is restored in our opinion, if the attorney cannot communicate with that person effectively, if there isn't a two-way communication process where the attorney feels that that person is responding effectively and or behaving or making decisions in a rational manner, critical decisions that really are going to impact their life, then the attorney may not feel comfortable proceeding with the criminal process. And so that's where an additional doubt is declared, an additional evaluation has to be done. Sometimes the attorneys have to handle and request a private evaluation so that there can be a better and more in-depth evaluation that it is not confined to what the doctor's limitations, some of the appointed doctor's limitations in terms of hourly rate or the amount of time they spend. Because remember, these evaluations are not all in-depth. They could be very cursory, they could be fast flashes, there could be an hour, 30 minutes, 45 minutes, and then, sending it back to court. So that's a major, major problem in the system that can be a source of a lot of delay.
Thank you.
And I think on that prong, Sylvia, Allison mentioned some of these cases can be set for contested court trials or jury trials. It's usually related to that particular prong, not really understanding the proceedings. Usually we can get people past that, but it's that second prong of rationally assist. Going back now to, if we get the next slide. the state hospital waiting list. So again, only felony incompetent to stand trial patients are sent to DSH. The wait time right now is currently 2 to 3 months. Patients will be waiting in county jail until a bed is available at DSH, and during that time, they can be giving meds voluntary or involuntary if ordered by the court. DSH now performs reassessments periodically where they may assess the individual that's waiting for placement at DSH and determine that person has regained competency. Those are done virtually now. Patients may also go to DSH, be restored to competency, return back to county jail to face criminal charges, and again be found incompetent. And that's what Judge McGowan was kind of talking about. Sometimes we see that revolving door of back and forth. There can also be contested hearings at that point. So if someone is sent to DSH, the state hospital says they're competent, they come back, their defense might not agree with that. And so we might have to appoint a new doctor and do another trial on that. And that could take a lot of time to do that portion as well. A person, I don't know if we mentioned this, but a person can be at DSH to be restored to competency for a maximum of 2 years on a felony case. Let's see, next slide, please. IST diversion. This is basically referred to as track 2. So these are individuals that we in Santa Clara County are diverting away from the Department of State hospitals. How does this work? Individuals who are found IST, incompetent to stand trial, on felony charges may be diverted from the state hospital into community treatment. And so this is what we're talking about. This is track 2. Whether an individual is eligible for diversion is dependent on their amenability to treatment, the nature of their crime, and both parties must agree. So how this works is Allison and I are in court. There's a case that comes before us where the person's incompetent to stand trial. The DA will look at the charges. Is there a public safety issue? Or is this a case that we're not too concerned that it can be community-based treatment? We'll say, this looks like it's a felony vandalism case, let's say, for example. I don't have a lot of public safety concerns, so I would agree to sending this to mental health treatment court for a track 2 assessment. Allison will say, I agree, let's send it to behavioral health in mental health treatment court for an assessment. They'll type up behavioral health, will then meet with the individual, make a determination, are they amenable, are they not? If they are, they'll let the attorneys know, and we will then agree to divert this person away from the Department of State hospitals to mental health treatment court.
And this is pre-trial, pre-sentencing.
Yeah,
Right.
it can
This
be
is
at any
the
point in the criminal
okay.
process, but generally it's before a prelim or before a trial, yes.
Okay. But there's another role in mental health treatment court that is only post-sentencing, correct?
Yes, mental health treatment court can supervise anyone with a mental health issue pre-plea or post-plea.
Thanks.
So we also supervise a lot of people in 60 through 62 who have pled guilty, but during the case we realized they could benefit from mental health probation. So they're there as well. But yeah, right now we're talking predisposition.
Thanks.
So yeah, the criminal court judge will refer it to 6061 for an assessment. The clinicians at behavioral health will meet with the individual, determine the level of treatment necessary, discuss housing locations, how can we get this person back into the community in a safe situation. They'll refer it, like I said, back to us for the determination if we're going to agree to track 2. If we do, they are then sent to track 2 to mental health treatment court to receive all the benefits that any individual in mental health treatment court would receive.
And this is a little bit different than felony cases that get sent to the state hospital, because in those cases there is a focus on the client getting restored to competency to be able to face their charges. In track 2, based on the nature of the charges and the individual client, the agreement between the district attorney's office and the defense attorney is essentially that the client will receive services in treatment court, not be restored to competency, and ultimately hopefully have their case dismissed if they've been successful through treatment with services in the community.
That's 100% right. And say, for example, the rare situation where maybe it doesn't work, they go off their meds, or it's just not working, we can then revoke that track 2 diversion, and it can be sent to the Department of State hospitals if needed.
It's a really interesting dichotomy that somebody could be successful in treatment, yet still incompetent to stand trial.
Yeah.
Question mark? Is that an accurate?
That's true, and it's
statement?
also, I think based on the types of charges it is, sometimes the district attorney's office doesn't feel the need to continue with prosecution. So at some point, the client might ultimately be restored to competency by taking medication and by having support in the community, but due to the nature of the charges and their success, it's not worth it for them to go through criminal prosecution or end up with a charge on their record or something like that, when the ultimate goal is to have them be a successful, productive member of society, and we've achieved that goal. There's not necessarily a need to go back and go through the process.
Yeah, agreed. And I know someone earlier said they like numbers, so I can give you some numbers. As it relates to Track 2, since its inception, there's been 173 individuals who've been referred to Track 2. 92 have graduated to this point. I think these numbers are maybe a month old. Track 1, which is just mental health diversion, an entirely different mental health diversion statute about getting someone treatment. 375 individuals have been sent to mental health treatment court. And Track 3, which is all misdemeanor incompetent to stand trial, 330 individuals have been sent to mental health treatment court. Hence why our treatment courts are very busy, but they're doing great work there.
Can you go back to those numbers again? And you started out by saying there was 800 and something that earlier in the presentation. Are all of these numbers a subset of that number, or is that in addition to?
In addition to. So the 800 number was the number of assessments that are done on year in Department 25. So those 9 assessors do about 800 and some assessments per year. These numbers that I just read off are individuals who are being serviced in mental health treatment court under those 3 different tracks.
Got it.
Let me see if I can help. Department 25 is the Track 1 felony. So that's the first number. I'm sorry, did I say that wrong?
Sorry. Our tracks are a little bit confusing. Track 1.
Oh, I'm sorry, you're right. The
Track
wrong
1
track.
is diversion where a client is not found incompetent to stand trial. This is a pretrial determination that is made by a court that the person, prior to being sentenced, prior to entering a plea, there's been a determination that they have a qualifying mental health disorder and would benefit from treatment in
That's
treatment
right.
court, but they are competent to stand trial.
I used the wrong track. What I was trying to
Apologies.
say is we have 4 courtrooms, and the number that Brandon was referring to was the felony courtroom, and then the other numbers were the mental health treatment courts and collaborative courts, if
Correct.
that helps.
So Track 2 is felony IST diversion,
Yep, that's away from state hospital.
and Track 3 is misdemeanor IST diversion.
Correct. And then Track 1 that Allison just talked about is Penal Code Section 1001.36.
Where there's no issue of competency to stand trial, but still would be better benefited from mental health treatment.
That's correct.
Where do the people go that are, what track or department, if they are not being diverted and they are candidates for the state hospital?
They simply go to the state hospital. They don't have a
tracks for
separate
them.
track. They
Okay.
don't touch our treatment courts.
Oh,
Got
it,
out of
okay.
Department 25, if they are not either determined not amenable for Track 2 or their charges don't qualify for Track 2, they get referred to South Bay Conrep, which is contracted with the state hospital. They will do an evaluation of whether or not someone should go to the state hospital or get community treatment through Conrep, which is separate from our treatment courts. Those aren't counted in the numbers in our
so the
treatment
3
courts.
tracks are all in the mental health court?
Yes.
All right.
May I ask one more?
Thank
just
you.
because this is not confusing enough, I want to throw.
But it's fascinating.
It really is. Could you talk just for a minute about what CONREP is?
Take it away.
And what that stands for? Is that an acronym?
Is it it's a place? It's an acronym. It's
So
an island.
Conrep is an organization. They have a few different roles. They deal with people who are released to the community after clients are released from the state hospital pending SVP and MDO and
MDO,
NGI.
yeah, we're gonna get into the weeds here, but
So if a person has been at the state hospital for being a sexually violent predator, having a mental disorder, or an not guilty by reason of insanity plea, if they ultimately get released from the state hospital, CONREP will be the point organization, I guess, for treatment and housing and placement in the community. They also have a separate role contracting with the state hospital where they do evaluations of clients before there's a determination if they should go to the state hospital when they've been found incompetent.
I like to
stand
think
trial.
about it as a mix of basically probation or mental health, behavioral health for DSH clients. So you've been to DSH, you're going to get out, you're going to step down into the community
probation or
under the supervision
parole?
of CONREP. Say it again?
Probation or parole?
I mean, it's just an analogy. They're not really at all the same, but basically think of it as a step down supervision role for someone who was previously at Department of State Hospitals.
Is it compulsory?
Yes.
Okay.
It-
So
it's like the
is it an
outpatient version.
inpatient, they're locked in the CONREP facility?
Nope, it's actually right here down
I'm gonna
on
read about that.
First Street. You've probably driven by it 100 times and never knew where it was.
Cool.
Because that was me. I was like, oh, that's where it is. I went and visited. It's
Okay.
right down the street. It's outpatient. They're living in housing. They just meet with CONREP once or twice a week.
And
They do
CONREP is
groups.
responsible for getting them housed and making sure they comply with whatever they need to comply with?
Correct. It's
Where are they housed?
all, that.
I mean,
know
in general,
that's a
is it-
separate role from
Okay.
what we do in the mental
I'll
health treatment
investigate
courts and
that outside of this
competency.
meeting
That's
then.
we do have someone from our office who handles those, and I think Sue Clemens would be
Okay, we'll stay on track with this,
better to answer
this
those
report,
specific
and I'll learn more about that
But
later.
maybe I'll just say one thing, because I think there is a connection there, which is
And what's that?
part of what we're dealing with and part of what the creation of these different tracks is designed to address is not only the challenges associated with getting timely evaluations to move through the process for folks who may not be competent to stand trial, but also really the profound underinvestment of the state in capacity at the state hospital, both for the folks who need to go there for competency restoration or the folks who will never be competent and need to go to state hospital because that's the place that they can be securely cared for. And there is a transfer of responsibility from the county level to the state where somebody does need to go to state hospital or where they are going to need to be held long-term and then sometimes treated in the community. But part of the lack of familiarity on all of our parts with some of the details is because that's a state responsibility. They have the responsibility for caring for them at state hospital and where they're not coming back to be adjudicated in our county to then figure out the outpatient
And the state
service array.
maintains that responsibility. How refreshing.
Doesn't meet it well and is trying to transfer a lot of it back to counties.
There they are.
I think the last important thing because it kind of relates to, they were talking about EPS last time and conservatorships. So I think the last point to make about someone who is incompetent to stand trial, who is sent to the Department of State Hospitals, we mentioned we have 2 years to restore them to competency. If we're unable to do so, or the Department of State Hospitals is unable to do so, or determines that that person cannot be restored, they're sent back to Santa Clara County where the judge has to make a call. Are we going to initiate conservatorship proceedings on this individual or dismiss the case? So that is the juncture where oftentimes we're only, in my opinion, the DA is generally only sending people to Department of State Hospitals who we feel there's a public safety risk. So at that point, when they come back 2 years and not restorable, it's generally our position that we're going to be requesting a Murphy conservatorship or an LPS. And sometimes we have that rub of the green of, can we get that person conserved? If not, there's nothing else to do but dismiss the case and hope for maybe we can send them to voluntary assistance in mental health treatment court. But that's another thing that I think everyone should know about.
And when that happens, it goes to 2 other courtrooms that are the probate departments.
Oh, probate for conservatorship. Cool.
And I
Okay.
think that was generally the last
Do try to
slide.
get to your last slide.
I think the last slide was just referring, once someone's referred via Track 2, they go to mental health treatment court to receive all the type of same services that anyone there would, whether it's residential mental health, SUTs, FSP, AOT, all the programs would be available to those individuals.
Again, theoretically, if there are spaces and slots and work, I mean, it's a big, I don't mean that as a counter to you, but that ultimately is the reality that keeps people safe and healthy, is whether they can get to all of the things that we know we have.
100% correct. I know you were asking about those numbers. I know behavioral health, Gabby, who runs that department, does a really great job of keeping active live stats of where people can go, how many beds are available. We can, not to put her on the spot, but I know that those numbers can be accessible and given to you.
Yeah.
They do a great job of knowing exactly how many beds and where.
I'm super interested in that. Thank you all so much. And Kavita, this was 65 minutes of a report that I hope, I know we've hardly gotten started, but I hope that indicates not only to all of you and everyone on the dais, but to members of the public that this is what we care about. So much of this work is an outcome of that declaration of a public health crisis in mental illness and substance use disorder. And what that has clearly led us to is a very strategic approach to better meeting the needs, whether we're adding beds or investing in workforce or really understanding where the bottlenecks are and what's happening so that we can improve the services. So I'm just very grateful to all of you for the presentation. I'm going to look first to the folks on the dais, whether or not you've already weighed in, to see if you've got questions, clarifications, comments for our team of brilliant attorneys, and then I'll turn back to...
I just have one comment about the data that we need to be looking at, and that is, from what we've learned, this is a very complicated, tedious, and a process that is very prone to a lot of delays at every decision point. And so I really believe that our success is going to be on the ability to divert as many people as possible without having to, well, that's the end, diverting to the extent possible. So the question is, how many are we diverting? How successful is that? And how and what can we do to improve that diversion process that is going to save from the litigation and save from the delay? So like, Brendan mentioned earlier, the issue is, the quality of the information that is given to the DA and to the public defender or the defense attorney. That's going to be critical, because I believe that if the prosecution and the defense can have confidence in the quality of the information that is coming from the experts that are telling the defense and the prosecution, look, this individual cannot be restored early in the process, or this individual at the root of it is this really complex mental health disorder. The sooner we can provide that information to the DA's office, the sooner we hope that there could be a stipulation, saving years and months of litigation and or delay. So I think that's a big important point. Like, how do we do it, and how do we do it earlier on in the process so that we save court time? Because Department 25 is heavily impacted. One critical piece here is, even in contested cases, we're waiting months and months and months, sometimes 6-7 months to get to trial. That's a horrible delay. And so our Department 25 is really heavily impacted, and we can't, afford to wait that long to go to trial on a contested case.
Thank you.
And just on that, I do just want to say competency is fluid. And so the longer the delays are, the greater the discrepancies are in doctors' evaluations. And so that's an important point.
Thank you. Molly, Public Defender O'Neill, sorry.
Thank you, Supervisor Ellenberg. I just want to make one comment, and then I wanted to embarrass Allison by first of all thanking her and the entire panel for this really dense, interesting, and provocative, presentation. But Allison has done over 10 Ironman races, and is not only this amazing mental health attorney, but stud as well. And then I wanted to go back to the content and follow up. so the state hospital doesn't have enough beds for ISTs, and they don't want to come get people. It's very expensive, so they do everything they can not to come pick up our folks who have a right to be restored. And for years, we've had to litigate around transportation issues. So if we filed an order to show cause as to why they were not coming to pick up our clients, they would bump our people up and then transport them. And other counties without sufficient resources to bring that litigation had clients languishing for months and years sometimes. What's happening now, unfortunately, is that if we have gone through the process that Allison described so clearly, and we have a finding of incompetent and an order to transport, they will send an evaluator down to do what we call a drive-by evaluation, see them very briefly, and then determine that they're not competent. And then we have to start all over again, and Judge McGowan referred to this kind of why it can bounce around a lot, and it's a really unfortunate turn of events, and I don't know if you all want to say anything else about that, but I just wanted to mention it because it's a problem.
Yeah, that is a big problem that started occurring during the delays that happened with the pandemic and the excessive backlog because the state hospitals were on lockdowns and they weren't transporting clients. So in order to alleviate their wait lists, the state hospital initiated legislation that allows them to do these early competency evaluations without the clients going through the full treatment process, which had been ordered by their commitment to the state hospital. Oftentimes these are very cursory evaluations. There is legislation that requires a subsequent evaluation. Once the state hospital evaluator does a virtual evaluation, there needs to be a subsequent finding that the person is not competent to overturn that finding by the state hospital, which causes great costs to the defense attorneys, the county. It causes increased delays in the doctor's evaluations because we only have a limited number on our panel. So the panel is then being required to do additional evaluations and adding additional clients. And so that is an additional additional concern from the side of the state hospital with the restoration evaluations, because we didn't even go into that that side of the restoration evaluation process, but that also creates huge delays.
Greta.
I was just going to kind of zoom back a bit and say, you know, all the complexity that we've been talking about with folks who are incompetent to stand trial headed to state hospital when state hospital has capacity, you know, we're really talking about the very deepest end. So the numbers that Brandon shared are really impressive in terms of how many folks in our community we've been able to send through this process, but they're obviously only a very small subset of the folks with mental illness or substance use treatment who touch our criminal justice system. And so I just wanted to, as we're looking at the kind of very deepest tip of the cohort of folks who have the most serious mental illness, to even be considered incompetent to stand trial is a very high bar. The overwhelming majority of folks who may in reality struggle to understand the proceedings that they're involved in because of a mental illness or substance use disorder won't meet that very high bar. And so just did want to make that comment to kind of make sure that as we're thinking about all the folks who touch criminal justice, who end up in our custody, who need treatment upon release, this incompetent to stand trial cohort is a very small subset, but the highest need subset.
Thank you. Supervisor Chavez.
Thank you. I want to ask my questions are going to seem a little all over the map because my understanding of this is a little all over the map. So in our custody annually, we then have approximately how many of the people that we see in custody are in some mental health process?
Do you mean a court
incarcerated.
process related to mental health, like mental health treatment court or IST, or do you mean receiving mental health treatment?
Of the 800, and then in each of the courts, the 800, the 300, the 300, the 300. So if are they are most of them in custody?
There we go. Most people, and Allison, correct me if I'm wrong, who are found incompetent to stand trial, remember, again, only on felonies and sent to Department 25, I would say a vast majority of those individuals tend to be in custody while they're meeting with doctors, being evaluated, and what have you. Flip side of the coin, many people in mental health treatment court, once we get them placed in the community, a large percentage of them are out of custody. Now they can go back and forth if they, what
Right.
have you, but.
So I'm thinking about the daily tally we get, and the reason I'm asking the question is that as we're thinking about what new types of facilities we need, I think having a deeper understanding of who's in our custody based on what you've just laid out is pretty critical for a number of reasons, but one of them being that. And I want to come back to the state's continued devolution of responsibility for human beings at all in the criminal justice system. And one of the things I'm very worried about is that as we think about the kinds of facilities we need, that we will not build out what we actually need based on the state being, frankly, very irresponsible with human health. And so I'm more saying this out loud to the Sheriff's Department and to the county exec's office, that as we're thinking more about how we're looking at who's in our custodial care, that the dailies that we get need to have a little bit more information, because I actually think it's really an imperative as we think about what it is that we need to build out. And I'm frankly a little concerned based on just what I've heard from all of you about the delays. And then on a separate note, just to say this out loud, that I feel like delay is an accepted part of our system. And I don't mean accepted because you want it to be the case. I mean accepted because it is the case. And one concern that I've had is the reliance we have on outside consultants for any number of parts of our system. I think it's true in family court as well, is a concern of mine relative to thinking about how we provide more robust services. And I think, Judge McGowan, the point you raised about how people are compensated, and then our expectations for experts being available when we are compensating them, it is a challenge that I think the courts are struggling with. I know the jails are. in a number of areas. So in any case, it's more of a reflection of two parts. One, understanding the who's in our custody in a very real-time basis. And then second, I do think we ought to be thinking about a time and cost study relative to the courts and our partnerships here, similar to the way we looked at housing and homelessness in another time study we're doing right now, because I actually think that fleshing this out is really important, because I also think it's a little like not only is the delay expected, but having people in custody that shouldn't be with us is also accepted. It's like, well, that's how the state's going to handle it. This is how we're going to respond. And I think we're going to need some evidence both to make legislative changes and then also to inform us about what services or what placement options we need locally.
I was just going to share, I think one of the areas where we may need to exert statewide leadership at a higher level on behalf of our colleague counties is in really thinking about what are the services that the state has long been expected to deliver, but to your point, has not been delivering or has not been delivering at the scale needed to meet statewide need, but really does make sense as a state function. And I'll just say what I mean by that, which is, we are a big enough community that we have a cohort of folks who have similar needs, but it really doesn't make sense to build a facility for some of these super deep end folks, even just with the numbers that we have in our county that would actually meet their need. The whole purpose of the state hospital is if San Benito County has somebody with these super deep end needs only once every 5 years, and that's true of a lot of our small counties, and then we may have a handful at a time, but not a consistent enough cohort to really build out the programs and services and facilities they need. That should be happening at the state level. yet it's not. And it continues to actually be also a moving target even for the state. So in fairness to them, as we've had changes in law that have given rise to a much higher number of Murphy conservatees, for example, which is something we've talked about here before, I think there's a need for real thoughtful planning at a state level around what will be the state functions, and then what is the level of investment needed to make those match the population statewide that needs those services, so that then we can focus our resources on those services we know will continue to be county responsibilities. And it's a struggle, because on the one hand, we always, our culture as a county is to lean in where we see a gap that's not being fulfilled at the state level, and yet, especially as we're entering more fiscally constrained times, that's going to limit our ability to do, for example, the expansions around crisis residential that we know are critical for a criminal justice involved population that we want to continue to divert as much as we possibly can. And then, of course, the community writ large who needs those services. So I know I'm preaching to the choir of everyone in this room around that, but I do feel like there are some opportunities we really need to avail ourselves of having pretty pointed and challenging conversations with the state about what our collective expectations as counties are of them actually stepping in to meet statewide the need that's emerging in every community.
Yeah, I mean, I think that that's part of the reason I want that data. I mean, it's not part of the reason. I think one other opportunity we have is that once we figure out how to get the data in an effective way, that's something that can be shared with the other counties, and we really should be at the top of our lungs fighting with the state about this. Let me move to another, on page, or slide 12, there is the last box here says, the law does not allow a criminal court to order placement into a locked psychiatric facility. The LPS process is the only basis to place an individual in a locked psychiatric facility. And one thing that I just want to raise is that I have had a concern for a while that our LPS partnership is not as robust as it should be, both in terms of having enough staff to provide those assessments. That's one concern I have. And the second concern I have is that the structure of LPS has been, in my opinion, for a long time, less responsive to the whole array of clients that they need to see. I think we're experts at working with seniors, and we are not leaning in as a county on this body of work, both relative to the public safety and justice system and even to our homeless population, especially folks who are so high need. I see them every day, and it's very frustrating to me that if I ask any number of leaders in the community where that person should be placed, it's almost always not the responsibility of their department. And so what I want to ask through the chair is for us to have a deeper dive on the role of LPS in this process with numbers that say, here's the requests we're getting, and here's the way we're providing and responding to those services. And I want to ask that, I think normally behavioral health is a part of this committee. Am I right? Is Sherry on this committee? Okay. So, Gabby, I know you are like you know everything. So I'm just going to look at you for a moment, Gabby, and say that with the presentation from LPS, I also would like that to be done in partnership with your office, because one request that I actually made of Dr. Smith some years ago was to consider pulling LPS out of SSA and making it its own direct body, because I think its alignment is much more integrated into the county systems overall, but by keeping it in one department, I think it also gives it a culture and an impression of a body of work that it should be doing versus what it shouldn't be doing. So in any case, through the chair, I'm confident, I'm very happy to have Susan help shape that discussion, but I would like behavioral health at the table. Thank you.
We will make that happen.
And then I could ask 1,000 questions. I'm gonna stop because we've had you here sitting there for a bit, and we'll ask some of them offline. Thank you.
Great. Then I'm going to look to the public to weigh in at this point, either in person or on Zoom.
currently have one request to speak in the room. Ray Kitty, would you please approach the podium?
If anybody else out there is interested in speaking right now, hang on before you start, is the moment to grab a yellow card and turn that in. The queue will close when this gentleman begins speaking if there are no other cards there. And for anyone on Zoom, are we Zooming?
We are Zooming. There are no requests
For
to
anyone
speak.
on Zoom, if you want to speak on this item, now is the time to raise your virtual hand. That queue will close when the first Zoom speaker begins. Welcome and thank you. Go right ahead.
My name is Ray Kitty. I'm on CCLAM, but I'm actually speaking as an individual completely. This is nothing to do with CCLAM, other than the fact that I love to see everything you all do, including the people behind me.
Could you increase his volume, please?
Sure. I love to see everything that you people do, including the people behind me. It's great. I wanted to mention first, CONREP stands for Conditional Release Program. I didn't hear that in the answers to your question. So, it's good to hear that people want data because I think the information sharing is behind a lot of the problems. I once asked a question of Judge Manley about how information is shared, and he said, well, how we do computer information sharing is we have the PD in a room with a laptop and the DA in a room with a laptop and the CHS in the room with a laptop and the court in the room with a laptop, and everybody looks at their laptop and talks. That's the computerized information sharing that happens, right? And I think when you're looking at the facilities, there's a lot of that too. Supervisor Ellenberg asked about slide 11 and all those boxes, right? What's the capacity? Are they full? There are lists and lists and lists of phone numbers people call. It's a random process to find where to find people, where to find places to put people. And apocryphally, I hear from some providers that they go to county contracted facilities and they go to the facility and they see it a half or 2/3 full, but then they call the facility to put someone in. Oh no, we're stacked to the rafters. For whatever reason, there seems to be, is there transparency about how much capacity there is? Is there transparency about how much is being paid for it? I mean, I look at the contract information out of procurement, and so for behavioral health, they have health-related services contracted $340 million. They have housing services, $20 million. Psychological services, almost. Okay.
Thank you.
All right. Sorry.
And we have no requests to speak on Zoom, so that concludes public comment.
Thank you. Then I'm going to make a motion that we receive this excellent report with the additional direction that we're going to get back from administration, some detail on slide 11 with examples of the types of facilities that exist in each box, numbers and availability, and I'll leave that kind of general enough for you to let us know what the best way is to present that, and direction to place on a future agenda a discussion item around LPS that should include certainly our social services, mental health providers, and I would think someone from probate court, unless you want to handle that or bring a friend from probate, I think would be helpful as well. So did I miss anything? Okay. Would you second that? All right, let's.
Vice
motion and
Chairperson
second.
Chavez
Yes.
and Chairperson Ellenberg.
Yes.
Motion carries.
Thank you all again very, very much. Item 5, which should be just as exciting, although it has 32 minutes or less. Quarterly report on county diversion and alternatives to incarceration efforts. Casey is presenting, and I just want to thank you again for the really good detailed ledge file that was just very clear and specific, and very much appreciated how it was laid out. Supervisor Chavez, did you want to?
I was only
weigh in
going to
with it?
ask if you, for meeting management, if you were still looking at 6 and 7.
Right, we've got more. Thank you. Good
But only
point.
so you could warn people if they
Yes.
needed to bring a sandwich or they wanted to wait till next meeting.
So, given the fact that this probably will take the remainder, let me look to Dr. Luna on the custody health services program. Is that something we can accept on consent without a presentation, or would you rather we hold it? I can't see her at all. Oh, hi, you're up here. I wasn't looking. Nope.
Your mic's still off.
We do not have a formal presentation, but happy to answer any questions. We do have folks in the audience that can answer questions on any of the aspects in the report. As you know, Custody Health Services is going through a transformational process. What you have in front of you really highlights areas I wouldn't call necessarily programs, but rather standard operating procedures. The only real program there is the peer support that we are struggling to launch, frankly, because it's so hard to hire people into this setting with lived experience, but we are trying, and we are happy to provide an update.
Frankly, I would
next
be
time.
comfortable holding this item. We've
I
got the
think so,
written
too.
report, and
Yeah.
there's so much more that's coming.
There really is.
Okay.
I mean, so if we could hold it to the
So
next
we're going to hold
meeting.
item 6, and item 7 is from the district attorney. And what is
Could we try to hear
your
that?
take? Do we, if we can, we can hear that, we can hold it, or we can, I guess we can't accept it because it's a verbal report.
Good morning. I'm Jason Malinsky. I'm in the Public and Law Enforcement Integrity Unit.
Could you speak into a microphone?
Sure.
We're not hearing the item right now. We're just figuring out how to manage this last half hour.
I wasn't intending to provide a report, just here to answer any questions that you may have.
Okay. Then if we have time for questions, we will do that at item 7, since there's not a report.
Perfect.
And if we don't, I would ask that we try to hit that earlier in the meeting next month.
Perfect. Thank you.
Okay, so I'll stick around.
So
Yes.
sorry, it's just another 30 minutes. We won't go over. Thank you so much. All right, item 5. Thanks, Casey. And thank you, everybody, for your understanding and shuffling around.
Good morning, Chairperson Ellenberg and members of the committee. Casey Halkin, Deputy County Executive. Today, I will be presenting on the quarterly report on diversion efforts and programming. Thank you for your compliments about the report. I really do want to thank, we have 8 departments that contribute to this report, and I would really like to thank them for their patience and time. You know, it was a 21-page report. It could have easily been 40 because of how robust and collaborative our departments are working together to both improve access to supportive services, but also to decrease recidivism and really enhance public safety as well. So they are myriad and impressive, and there was a little bit of truncated work that went into getting this legislative file into something that was, I think, digestible for all of us. So before I move on to any comments, I really did want to open it up to our departments that are represented here today to see if there was anything that they would like to add to the information that was included in the report, keeping in mind that we did have to edit some of it for just, again, readability.
Public Defender O'Neill.
Thank you, Chairperson Ellenberg. Just 2 quick points. One was, I really wanted to, we were asked to supplement our quarterly report this time with additional efforts our department is engaging in to reduce the jail population, as well as our thoughts on what may be contributing to higher jail numbers. So I think what I intended to say got a little lost in the ledge file with respect to the increasing the numbers of folks in the jail. The expiration of zero bail, from our perspective, really causes the average daily jail population to be 400 more people than it would be otherwise. So I wanted to make that point. And the other thing, I had some communication with your aide yesterday with Auden related to county parole, and I can talk about that, or I can save it and we could actually do a presentation on it at a later date. I know we're short on time, so I wanted to ask you if you wanted me to do that or save it.
I'd like to hear this report. So, if we, from everybody, this is a really important one.
Oh, agreed. But do you want each one to report out, or do you want to ask questions based on the information that they've all provided in the report?
Your call on that.
Okay. I know we both do our homework, so based on that, I am confident in saying that we can go to questions of each of the sections in the report.
Let's do it.
Right.
And I do want to note that we have CEO Program Manager Amanda Ayala who will be assisting. We have the slides for the jail analysis queued up, should you want to review those. And we also have Gabby Oliveras from Behavioral Health available who can answer questions. And then most of the departments are, of course, represented on the committee.
Perfect. Would you like to begin, or would you like me to?
Would you? Thank
Sure.
you.
Yeah, I'll just start really again with appreciation to all of the departments. I think we've really gotten to, particularly with regard to the jail population section of the report, exactly where I was hoping.
I'm so glad.
It would go with the graphs of the different population metrics and the brief narratives describing what the trends in the metrics mean. I thought this was very clearly laid out. And it's easier, much easier now to understand the trends relative to the goals of diversion and alternatives to incarceration. And I have really just a couple of brief questions and comments for a couple of the sections. For the public defender's report, Molly described that misdemeanor diversions, I'm just going to quote from the report, generally involve a 6-month term. Oh, was this public defender or probation?
Public defender.
It was? It generally involve a 6-month term where the client remains crime-free and participates in anger management counseling, theft awareness, gun safety, driver safety, or case-specific terms unique to the facts of their case. What I was curious about is just sort of the, perhaps in some cases, paternalistic or really directive nature of this direction, sort of presuming that people need to be taught a better way to do something as if they didn't know, which may be true sometimes, but I'm wondering also how we're giving consideration to really addressing the potential root causes that led to these actions, which could well be that folks need money, housing, employment, family issues, other pieces, as opposed to, or at least in addition to, a class telling them how to do something better or what bad thing not to do.
Thank you very much for that question. I think it's an important point. And I would just say misdemeanor diversion involves really low-level offenders in the criminal legal system, generally speaking.
Right.
And misdemeanor diversion, unlike some other diversions, is really pretty flexible around conditions of the diversion. So if it's a theft case, it could be theft awareness classes. But we try when we're dealing with clients to assess, in a holistic way, the needs of the clients, if it be housing or substance abuse, and working to develop diversion for those misdemeanor clients to include those in it. So we may refer to one of our social workers to have a look at housing or addiction needs, and the court may order some other conditions relevant to those needs. So I hope I'm answering your question.
You are, because it sounds like we're not only doing these things, and if you're comfortable with them, that gives me some confidence. I was also interested to read about your office's efforts to improve the use of county parole in partnership with Assemblymember Lowe's office and the Sheriff's Office, and was wondering if either you or Sheriff Johnson could talk a little bit more about what that effort is.
Sure, perhaps I could start, and then the sheriff and or the chief of probation may want to jump in, since they each are entitled to have members of their staff on the county parole board. So I never heard of county parole until 6 months ago, when the board-appointed community member, Lon Allen, at this time came to our office and said, "I want to talk to you about county parole." And I said, "Great, tell me what it is." So apparently, and I included it in this report because it's a mechanism that could be used but isn't being used to reduce the jail population. So basically, if someone is sentenced to a county jail term, and say it's 9 months, at some point along the way, that particular incarcerated individual might be identified as someone who could be released early, do well on the outside, and could serve county parole. It's codified in Penal Code Section 3081, and it's not been used in our county for several years now. So what happened was we went, first of all, with Lon Allen, the community appointee, to meet with Assemblymember Lowe, who, and the reason for that is that the reason the program's not being used is because it doesn't afford credits to anyone released early while they're outside, which most other release programs now do, so it's outdated in that regard. The other thing is the period of supervision is too long. So the law has changed even with probation supervision, but this statute requires a 3-year period of supervision. So nobody really wants to do it, and we haven't really been working to identify clients. But Assemblymember Lowe has expressed interest in changing the language in the statute to bring it up to date with best practices. And we met with members of my staff met with the sheriff 2 Fridays ago, I believe, to talk about what a process would look like. And we are currently reaching out to other jurisdictions. I believe it's Kern and San Diego who are using county parole. So it's
Those
great.
could not be 2 more different counties. It would be fascinating to see how they're doing it.
Well, and it was used some during COVID to effectuate releases. So we're trying to work to get it up to date and then begin to use it. And the sheriff is on board, and I'm sure Chief Burchard would also. We don't even know, since we didn't know anything about it, who the other members of this parole board that doesn't get used, who has 0 clients to deal with, are. But anyway, that's kind of the rundown on county parole, and we're doing everything we can to get it usable and up to date.
Thank you. Interesting. Anybody else need to add anything? Or that was fine? Thank you. Yeah, I didn't know about it either. I just have one more point that I want to make. Regarding the increase in EMP clients that was shown in the probation department's report that was due to an expansion in eligibility criteria, Chief Burchard, can you just share what that expanded eligibility criteria is?
Yes. Couple years, year and a half or so ago, we looked at the current criteria that we had on adult EMP, and in an effort to help with the jail population and looking at that criteria, there were 3 different suitability criteria that we expanded so that there were more folks who were eligible. The first one was clients charged with felony domestic violence charges are now assessed by the probation officer for eligibility and suitability based on a variety of factors, including housing situation and their history. The second are clients living in temporary housing, THUs, or sober living environments are now eligible. In the past, they were not. And then the third is clients who have less than 15 days of a jail sentence are also now eligible as well. So those 3 criteria changes has allowed us to have more folks that are eligible for probation EMP supervision.
And those as a category, does that represent a lot of people? Is that a significant, I mean, it's significant to each one of them, but overall in terms of population?
Significant number to increase, not so much, but it does represent some folks who are now eligible that weren't eligible before. And so we're trying to make sure that we're keeping public safety at the forefront and at the same time give folks an opportunity to be out of jail.
Thank you. Yesterday at the JJCC meeting, in one of the presentations, we heard that at least for juveniles, that the data is showing that there's no significant difference in rates of juvenile probation term completion between those who are on EMP and those who are released without that bracelet into the community, which to me would suggest if we keep collecting data like that, number one, we should be able to reduce the use of EMP for youth. But if we also have good data showing that the outcomes are about the same, it's something the courts might be interested in looking at in terms of your willingness to let people remain in community without that electronic monitoring. I know we just approved a huge contract increase at the board meeting on Tuesday, and I certainly understand that being on a monitoring device is a tremendous improvement over being incarcerated, but it also has the potential to be overused and to make kind of recovery, restitution, any of those pieces more difficult for folks, and certainly has that added stigmatization, which may make other aspects of their lives possible challenging. And certainly we have to weigh the safety implication. I'm just noting that if we start to collect this kind of data, that there's not a lot of difference. I think we'll be able to argue for reducing the usage to be seen.
Yeah, and to your point, on the juvenile side, and they're very different, juvenile EMP, the majority of youth who are on an electronic monitoring device are pre-adjudicated. So what this does is save.
Is that not the case here with our folks?
On the adult side, it's through Matt's folks. On the EMP, ours are post-sentence folks that end up on our adult EMP. In the juvenile world, the majority of it is yes.
Your adults with Matt's adults.
And the juvenile
No,
as
I
well.
understand the
yeah.
juveniles.
But I mean, as far as the intent
So
is.
you do post-sentence
We do
EMP.
both. We do both. On the juvenile, we do both. We do pre and post.
Right.
On the adult side, we just do post.
Got it. So I was actually thinking that your data could support Matt's efforts to reduce the number of people that need to be on the EMP as opposed to just being released. Is that a legit comparison, or is that too different? I'm getting a head
Yes,
shake
no,
from the
I agree. I mean, there are some comparisons from his adult EMP and our juvenile pre-release EMP. And it really is just about the days saved that a young person, anyway, would be in custody. And I think last year it was roughly 1,900 days were saved that youth were able to be out while they're pending court and going to court. Legislation has also changed to make sure that a young person doesn't keep an ankle monitor on for 3 months, 4 months, 5 months while court is going on. So there's a review now every 30 days in court. And so if we can step a young person down from an ankle monitor to just community release, we will, and it's done during that court process with the public defender, district attorney, and probation adding comments.
Thanks. Matt, is that relevant to your work?
It is. The chief said it very well. One of the things we're focusing on, well, maybe Kavita has some of those Venn diagrams, because that's kind of what it looks like. I'll say that one of the things we're focusing on is the duration. Are there ways that are low risk, low cost, low disruption to the court? Because when we go back to court, that's more work for everybody. We're already addressing a backlog altogether.
Right.
So we are going to be coming back in the spring with some more information for you about efforts to shorten the duration where appropriate. I just wanted to point out one thing that some may not be aware of. There's a group of probably 400 individuals that are on voluntary home detention. They're out of custody. They are active in the community. It's home-based, but they go to work, they go to church, they go to counseling, they go to the doctor, and they get prospective credit for time served. Should they be sentenced to jail time and they're successful, they're getting credit for days they would otherwise have had to go spend in jail.
And are they on a monitor?
Yes.
At home monitor?
Yes.
Thank you.
Can I just follow up on the monitor piece? So in the board meeting, there was a reference to, thank you. There was a reference to the monitors limiting a person's ability to do any of the things that you just talked about in terms physically. And so could you just spend a minute to talk about how often that's really the case? Because what I'm having a hard time understanding is sending someone home with an electronic monitor and still not letting them go to work.
Sure. Actually, the judges are really, they're really well versed in kind of what are the rules, what is the structure that we have. I'll say it this way. The person's on electronic monitoring, their life looks a lot like mine. I'm back and forth to work. I go to the doctor. I'll say that I'll go to school, that sort of thing. So if it's productive, it's most likely permitted. What we're regulating is certain criminal behaviors, being away from certain people and places. And sometimes we regulate a schedule. Well, we always regulate a schedule when it comes to work. When it comes down to errands, there's no such thing. Errands is we need to know what they're doing and be able to go back and get it.
So the reason I'm saying that, asking this, is that I don't know who, but somebody said we think these monitors are impacting people's ability to get, to deal with their personal issues. If that's not the case, I think it's really important that maybe somebody do an off agenda to the board, because that came up in a board meeting where someone said that the monitors were impeding people's ability to go to church, go to work, do those pro-social things that we would like them to do. So if that's not the case, we should explain under what terms and conditions that is the case.
I'd be happy to provide more information. I could make the argument that it actually helps people to do those things. It gets them into kind of a positive behavior reinforcement. They're on a more regular schedule. They're getting more rest at night. I mean, a lot of things improve. However, we're all concerned about net widening, from everything from the risk assessment through diversion. And it's a struggle to do these re-reviews, but I think that's one of the most helpful things to do. Somehow be able to share information and to review cases so that we're applying the least restrictive conditions that are reasonably necessary to that person's needs, prioritizing public safety.
Thank you. That's very.
So that was my comment, and it was from anecdotal understandings of.
Got it. Okay.
Somebody wasn't able to go to their child's school to see a play. I think the decisions are made, and I'm happy, Matt, for you to spell this out in a report. I don't know that there are blanket rules that you can always do certain things. I believe that there's individual determinations of what people can do, and then of course there's just the physical visibility of the bracelet.
that makes more sense to me. I think that if
I didn't mean to imply that it prohibits everything, but it certainly makes your engagement and kind of trying to be a productive part of the community harder.
I totally understand that. I think the reason I think it might be beneficial to have the report is, again, so we can share it with the courts, and again, so the courts can make decisions about that. Because in some instances, if we are giving people electronic monitoring who have a history of domestic violence or child abuse or any of those other things, and the court doesn't want them connecting with at the children's school, or they've got a restraining order of some sort, I also don't. I want to make sure that that we're doing what we can to be pro-social and really protective of victims as well. And so that's how I interpret the distinction there. But now, I also think, as we're thinking about tools and studies and all of that, and this just would be blanket to everybody, is that I want to make sure we're really engaging the courts, because I think that what we want to be able to do is produce for all of our partners what are those effective, practices and non-effective, so that we're dealing with as much facts as we can be. Because frankly, I think that the idea that judges feel more comfortable letting somebody out if they have that electronic monitor, it to me is part of the way we want to go. But I understand the point you're raising. Susan, were you done with your questions?
Yes.
Okay.
Yes, and thank
so
you.
if I could go to the jail population trends, and this is on page 3 of 17. And these are really interesting slides where it has the total number of folks who are in custody, the total number of felonies, and the total number of misdemeanors that are, so on the top slide, it has 219. Well, let me ask what I'm looking at exactly. Is this a snapshot at each quarter, or is it an accumulation of the quarter before?
And I was just signaling to Amanda to pull up the slide. She's looking at the one with the bars in the
Oh,
large
thank you.
green color centered.
Yes, thank you.
That one.
Perfect. Thank you. Thanks, Amanda.
And I'm sorry, would you mind repeating your question one more time?
Yeah, Casey, is that a snapshot at a point in time, or is it?
No, it's a snapshot.
Okay. So then, if I'm reading this properly, it's still alarming to me how many folks are sentenced versus not sentenced that are in custody. But if I'm looking at this, in the green felony unsentenced and the misdemeanor unsentenced, could you just say a little bit about who the misdemeanants are? And what I'm really trying to understand is how we treat potential violence as an indicator of somebody staying in custody versus, being in a program outside.
So this information was pulled from our data analysts with pretrial services, but I did have some follow-up questions that I actually asked the district attorney's office because they have the most robust access to the CJIC data. One of the challenges with the misdemeanor population in particular is it's not the full story of that individual. So you may note that there's 257 people in custody on any given day who are there for a misdemeanor case and are unsentenced. But until you look at every individual case, you won't necessarily know whether or not there's underlying cases. The reason why that's important is there have been times where it's looked like the misdemeanor unsentenced population is much more significant, and there have been concerns that there might be a much more robust opportunity for diversion than we are employing, and I certainly think there's room for improvement. But in order to really understand that group, you need to look at an individual case by case to understand if there's additional misdemeanors, more significant cases underlying it, or reasons why that person would need to be in custody, even if the case that they are technically in custody for is nonviolent. And that requires a really in-depth, time-consuming point-in-time analysis of all of the people in custody to better understand those trends, which is something that is very time-consuming and needs to be done by, experts who can really look at those cases individually to better understand where there's room for improvement with our misdemeanor population.
Let me just add one thing, which is though, and Casey or others on the dais can correct me if I'm wrong, but there may be somebody who, for example, had pending felony charges, was out of custody, then commits a misdemeanor and is remanded based on their commission of a subsequent crime. So the offense that triggered their incarceration was that subsequent misdemeanor, but the only reason they're in custody on a misdemeanor is because they had other pending, more serious charges. And that is why I think just anecdotally, that bar is a little bit hard to unpack because you have to look at what would be the other underlying charges that may be the real reason the person's in custody.
Yeah, I think that's helpful. I guess what I'm mindful of is that as we're producing information like this for the public, and frankly, I didn't know, I had to look up what misdemeanors were because I always thought of misdemeanors as being, we refer to them as low level, but sometimes they're really not. And there's an area. And so the only reason I'm asking this question again is I think for all of our partners to be able to understand who's in custody, I think would help us understand a little bit more about our jail population in terms of the way the police and the courts and all of our partners look at it, and also frankly be able to help us do a much better job of assessing services or needs than I think we can do with the big bars. And I do appreciate the point. And as a matter of fact, what also was a little confusing to me is to look at the chart right below it that has the total population with the total number of.
Yeah, there we go. This one?
That monthly, the on the booking, those numbers were a little confusing to me too. But recognizing the time issue, I'll spend a little time with staff digging in so I understand those a little bit better for our next meeting. Thank you.
Thank you so much. This committee does suffer from too much fascinating information and robust discussion. I appreciate all of you, but I also always want to be very respectful of your time, and with apologies to the ADA that we are not going to get item 7 today. So we are holding 6 and 7. I earlier said to November. I, of course, meant December. Do we have any announcements under item 8? I'm seeing, Javier, please. You turn your mic on, please.
The Mission to Recovery Station will be relocating to their new location effective Monday. So we let all of our law enforcement agencies and all of our providers. So they're just moving the same place at the Reentry Resource Center, but at a different location. And then the pilot project with San Jose PD on the misdemeanor driving under the influence was launched on Monday, October 16, and over 2 weeks, we received 17 individuals. And October is now our highest at 187 participants for Mission Street Recovery Station. Thank you.
And I would only just add, Supervisors Ellenberg and Chavez, if you have not seen the beautiful new space we now have available at Mission Street Recovery, it's really worth a visit. It is a move within a facility, but the new space in which we're offering that service is so profoundly better and expanded, and so it's a program that we're really excited about.
Thank you. I did have the opportunity to see it, and it certainly is an improvement. It's just my coffee. Quickly, there are 4 district representative seats that are open on the Child Abuse Prevention Council that I want to make sure you're all aware of and think about who you are going to recommend to be appointed. The seats are open to residents from districts 1, 3, or 4 who have a background in the child abuse prevention field and are active in the community. Interested applicants should go to the Boards and Commissions page on the clerk's website to submit an application, and certainly there's a lot of important work going on in this commission that is stalled when they do not have quorum. So really hoping that all of you up here might think about recommending someone to apply to the commission. And with that, I see no more lights for announcements. We're adjourned. Oh, that was a... You want to...